We would like to acknowledge the traditional territories of the people of the Treaty 7 region in southern Alberta, which includes the Blackfoot Confederacy, comprising the Siksika, Piikani, and Kainai First Nations, as well as the Tsuut'ina First Nation and the Stoney Nakoda, including the Chiniki, Bearspaw, and Wesley First Nations. The City of Calgary is also home to Métis Nation of Alberta, Region 3.
Good afternoon and perhaps good evening to some of you. Thank you for joining the School of Public Policy's Extractive Resource Governance program today for another webinar in our series on Canada's Indigenous peoples and resource development. The ERGP's mandate is to share Canada's expertise in responsible and sustainable resource extractions with jurisdictions domestically and around the world. Natural resources bring opportunities for people to enjoy economic growth and prosperity. But to achieve this economic benefit in a manner that protects social and environmental values, it is important that organizations have the tools to build systems of legislation, regulation, and policies with the perspective of its people, particularly those affected by development, clearly understood and considered. In that context, it is my honor and privilege to chair this webinar, and what I hope is that we are contributing to the work that reimagines resource development within the framework of reconciliation. It is my pleasure to introduce to you today the moderator of this webinar, Dr. Heather Exner-Perot. Dr. Exner-Perot has over 15 years of experience in Indigenous and Northern economic development, governance, health, and post-secondary education. She has published and or presented on Indigenous economic and resource development, urban reserves, telehealth, and numerous other issues. Thank you, Dr. Exner-Perot, for moderating this panel discussion. Mazi Cho, over to you, Heather.
All right, thanks so much, Deborah. Good afternoon, everybody. It's my pleasure to be here with you today to talk about Blueberry River, Ermineskin, and Grassy Mountain cases and their implications for Indigenous rights and resource development. So these are, we chose these cases, some decisions have been made in the last couple of months that I believe could have sweeping implications for resource development, Indigenous rights. And certainly, I don't know, Christine, if I'm not appearing on the slide, I don't think. If you can make me the presenter, I'll let them figure that out. I'll keep talking. But these have sweeping implications for how resource development may proceed. And of course, many Indigenous rights cases have had those kinds of implications in the past and have had those sweeping implications. But this comes in a context where now commodities are booming, Indigenous nations and businesses are becoming more involved in resource development, and we're facing an energy crisis and a climate crisis, both of which will require more Canadian resources. So it is very important that we get resource development right in Canada. So to help us understand what these different cases mean, all the implications, we have a fabulous panel of experts. I have Sandy Carpenter, who is the co-founder of Canadian Regulatory and Indigenous Law, Ryan Robb, who is the CEO of Stoney Tribal Administration, Carol Wildcat, who is the Consultation Director of Ermineskin Cree Nation, and Professor Dwight Newman, who is the Canada Research Chair in Indigenous Rights in Constitutional and International Law at the University of Saskatchewan. I do regret, for some of you who are looking for Councillor Robb from the Blueberry River First Nation, unfortunately, she's ill today, so could not join us. So I'm very grateful for Sandy for stepping in at the last minute, providing his expertise as we discuss these things. So just before we begin and move on to our panelists, I'm going to just start with a very high level overview of what these three cases are for those of you who aren't terribly familiar. In the case of Blueberry River, the BC Supreme Court agreed in a decision in June that the cumulative impacts of development had violated the Blueberry River First Nations treaty rights. Of course, they're in Treaty 8. The judgment found that the province's regulatory system for assessing cumulative effects was lacking, and that the province cannot take up so much land that the Blueberry River people can no longer meaningfully exercise their rights to hunt, trap, and fish in a manner consistent with their way of life. The BC government did not appeal. I know there were many concerns in industry what this meant. A lot of permits were frozen, But in fact, there was another movement kind of agreement announced last week between BC and Blueberry River allowed for 195 of those permitted works to continue and provided $65 million to fund work to heal the land and create jobs with land and water reclamation. So one more big, I guess, movement in the case last week. In the case of the Ermineskin, and of course, we'll get to Carol shortly, the Ermineskin Cree are one of the 4 nations of Maskwacis in Western Alberta. They contested a designation order that the federal minister for the environment, Jonathan Wilkinson, had placed on the phase 2 expansion of Vista coal mine in July 2020. And the Ermineskin, appealed this decision, and the judge agreed with them, saying that the federal government had inexplicably froze out the Ermineskin from a very one-sided process and ordered them to review their order. The judge, or the minister, quickly reviewed the order, I guess, because last week from Milan he said that the order will stand, and I'm sure we'll get to Carol's opinion on that. In the case of Grassy Mountain, Benga Mining is proposing to construct and operate an open pit metallurgical coal mine near the Crow's Nest Pass. It was subject to an assessment by a joint or federal and provincial review panel and determined not to be in the public interest, despite all Treaty 7 First Nations and Métis Region 3 having signed agreements with Benga and providing letters that they had no objection to the project. And so in this case, Stoney Nakoda Nations, and I think Piikani are also involved in an appeal, have made the decision to appeal this decision, finding that the decision was flawed. And we'll hear more from Ryan on that. So why are these all important for me? There are some implications. There may be enormous implications. First, that governments have to better take into account cumulative impacts, because the right to hunt and trap and fish is endangered in many places. This may have many ripple effects. And in the case of the Ermineskin and the Grassy Mountain, that government must take into consideration Indigenous people's economic rights. And maybe we're moving into an era where Indigenous rights does not just prevent government from saying yes to resource projects, but may also prevent them from saying no. So we're going to hear from our 4 panelists as they provide some open remarks on their understanding of the cases, their impression of the cases, and the implications. And then I'm going to have a few questions for them. But I will hope to reserve at least 20-25 minutes for audience questions. We have a very informed and knowledgeable audience, and we hope to hear from you and maybe you can get some free legal advice from Sandy and Dwight and ask your questions in the Q&A. So to get us started, I'm going to first turn it over to Sandy Carpenter, and let's see if we can get your face onto the big screen here.
Am I there on the big screen, Heather?
Yes, you are, yes.
Perfect, and apologies to anybody who said they heard me shuffling papers in the background. I've got my earphones in, so if I was shuffling papers, I didn't hear it, but I didn't realize it. Thank you very much for having me. Really appreciate it, and the opportunity to share some thoughts. I'm not going to share any thoughts on Ryan and Carol's cases at this point in time. More than happy to jump in later. But you guys are close to these issues, and I think that first dibs on them should certainly come from you. I will share some thoughts on the Blueberry case. And as Heather pointed out, and I won't cover everything that she said, the Blueberry case is significant. In Blueberry, the Blueberry First Nation had been complaining about cumulative effects in its traditional territory for years, and as long as I can remember. And I've been doing this for a long, long time. And the province of British Columbia got the letters, it got the memos, it got the phone calls, and it was constantly, we're doing something about this, or you should speak to so-and-so about this. And ultimately, the Blueberry were not happy with the province's response, and the development within their traditional territory continued. And ultimately in 2016, they sued the province because they said they were no longer able to exercise their treaty rights. And as Heather said, ultimately they were successful. And I think that the big difference in Blueberry from what a lot of you who follow developments in this area of the law is, this wasn't your normal sort of duty to consult case. somebody said, you know, my hunting rights will be affected in this particular case, and so therefore you need to consult with me, and you didn't do a good enough job, and I'm trying to take that to court. This case was about Blueberry actually saying, I'm not just going to assert my rights. I'm going to go to court and I'm going to prove what rights that I have under Treaty 8. And that's what they did. They did it from the perspective of somebody who has worked in this area for a long time in an amazingly short period of time. So, you know, the traditional thought has always been, well, it takes 20 years to prove rights. And so some First Nations just go, well, I'm not going to bother. The reciprocal of that, if you will, sometimes is, and I'm not going to suggest all the time is, well, we don't really need to worry about that right now because it's going to be a long time before they prove their rights. So we just need to deal with them as assertions, if you will, at this point in time. But Blueberry set out to prove its rights, even though it paused for a couple of times to negotiate during the course of the proceedings. Ultimately, from start to finish, including almost a 2,000 paragraph decision from the BC Supreme Court, it took roughly a period of 5 years, which is an amazingly quick timeline on something of this nature. The case is clearly significant from Blueberry's perspective. They would not have brought it otherwise. And we often hear about First Nations and Indigenous people attempting to protect their rights. And then, and I've been caught in this position more than once, suddenly it turns out that, oh, well, we reached a deal. And this wasn't this case. This was a case about putting a line in the sand and saying, we're going to defend what's left of our traditional territory. So the case is of obvious significance to the Blueberry and obviously to the provinces we'll get into later. But it also has broader significance, and I expect that Dwight will probably expand on this. But if you read the case, and don't be daunted by the fact that it's 2,000 paragraphs. It comes in bite-sized pieces, and it's a fascinating deep dive into what went on when Treaty 8 was negotiated. And it's a fascinating deep dive into what's gone on in Blueberry territory over the years and into the provincial regulatory regimes and how they try or not to cope with these issues, and the different perspectives of Blueberry and the province of British Columbia in this case. But beyond that, the conclusions that the judge makes with respect to Treaty 8, there's no distinction in those between Blueberry and all of the rest of the First Nations, if you will, in Treaty 8. In fact, there is a relatively deep dive to the extent that the oral and historical records show what was promised to those Treaty 8 First Nations who initially signed Treaty 8 back in 1899 at Lower Slave Lake. Very little discussion of what took place when Blueberry adhered to the treaty in 1900. It wasn't a big deal, apparently, at the time. So hard from a practitioner's perspective to distinguish what was told all First Nations in 1899 from Treaty 8 First Nations as a whole. So somebody who wants to say, oh, well, this is just about Blueberry, this may not just be about Blueberry. Heather mentioned hunting, fishing, trapping. We all resort to those sort of little boxes, you know, when people are out there consulting with First Nations. But what the judge found here was, it's not just about hunting, fishing, trapping, it's about a way of life and how those activities fit within Blueberry's way of life and how they fit within Blueberry's seasonal round and how important it is to the maintenance of who they are that those activities in the way that Blueberry has practiced them for thousands of years are able to continue. The case also has significance both within Treaty 8 and perhaps in other numbered treaties for its interpretation of the taking up clause. And some people suggested that the taking up clause could go all the way to, well, if there's no ability to exercise the rights left at the end of the day, then finally you get into the point where maybe the Crown has done too much under its ability to exercise its taking up clause. And the judge said, no, I disagree with that. There's got to be a middle line between you can't take up any land and you can take up all of the land. So her conclusion was you can only take up so much land to the point where it has a meaningful impact on the exercise of Blueberry's way of life as they understand it. It goes on and on and on. The conclusions with respect to the oil and gas regime, the forest regime, the wildlife regime, the cumulative effects regime in BC, all were found wanting. All were found to basically not take into account anything with respect to cumulative effects in the big scheme of things, and very little with respect to treaty rights, even though we've all been living in this world with respect to the duty to consult for years and years and years. And the last point I'll make, and this goes even beyond the Indigenous issue, is there may be other cases out there on cumulative effects that make this point, but most of the cases that deal with cumulative effects deal with it as this hypothetical thing. You should have considered cumulative effects. Cumulative effects are something that is required to be taken into account as part of a decision-making process. Blueberry shows that cumulative effects are real. Blueberry highlights that cumulative effects aren't just real, but cumulative effects can be devastating, not just in this case to Indigenous people's way of life, but to the various resources and habitats and other systems that are relied on out there. And so for people who are out there saying, I want to make an argument around cumulative effects, this is a case that they are going to be able to point to and say, here's the evidence. This isn't just a hypothetical exercise. This is a real thing. And so to go back to Heather's comment about living in a world where we're in transition on a whole bunch of issues, and including the cumulative effects of all of what we've done before and all of what we're proposing to do now, I see this as being a touchstone going forward. So I'll just leave it at that, Heather.
Fabulous. Thank you so much, Sandy. So while that case highlighted, and we say that, you know, we typically go back to hunting, gathering, and fishing, the next two cases also really talk about how that's not, you can't reduce Indigenous rights just to hunting, fishing, and gathering. Self-determination, economic rights are also part of it. So Ryan, why don't you tell us a little bit about the Grassy Mountain case and the involvement of the Stoney Nakoda?
Sure, thanks, Heather. And I'm Bawastich. It's a wonderful day from here in Morley. Just as a bit of background, the Stoney Nations, as mentioned in the opening, is comprised of the Bearspaw, Chiniki, and Wesley First Nations. We also have 3 reserves, 3 land masses. Morley, which I'm sitting in today, which is sort of halfway between Calgary and Banff. We have another one called Bighorn, which is up sort of close to Nordegg, Rocky Mountain House area. We have a southern reserve called Eden Valley, which is mostly straight, a little bit west of Longview. So Grassy Mountain, for those people that don't know, is down in Crow's Nest Pass in the very southern part of Alberta. It's probably less than 80 kilometers from our southern reserve in Eden Valley to get to. And for perspective, it's also a metallurgical coal mine, is the proposal from Benga. Important for me to describe at the beginning, Stoney, we are agnostic to coal and the production of it. Our appeal actually doesn't have to do with coal per se. We actually have three main issues on it. Just before I tell you those issues, It's important for us to also recognize that this mine and part of our appeal is actually on what's called Category 4 mine lands. Now that's already disturbed lands. I would like to use the term brownfield. However, I've personally toured it with our chief and councils. I think a better term is black field. Nothing grows there. It was abandoned, I'd have to ask them, 50 years ago. And there was no remediation done, or the remediation was done to 19 standards 50 years ago. So that led us to take a look, and really there's two things we're now appealing. And one is the joint review panel that came out from the AER. The other is the federal decision, which then came subsequently, but has now been in front of this discussion. So the joint review panel, and it's very similar that we're going to argue on the federal, although there's a little bit extra. There's three main issues that we were concerned with. The first of which is, and Heather mentioned it at the beginning, is IBAs, or income benefit agreements. We call them different things in industry, but income benefit agreements were in place with all of the nations of Treaty 7 by Riversdale Benga at the beginning of this process. The JRP came back, and some of the language around it was provocative at best. And it said, regardless of the nations having agreements, we effectively know better. And we are going to therefore disallow this application. Now, that's concerning to us, obviously. And there's a bigger question on IBAs and how do those work. We tend to treat IBAs as the culmination of consultation, right? We need to work on, in a nutshell, you need to work on our traditional use, our traditional knowledge. You work all of those, and then is there a commercial deal? Quite often there is in IBAs. I can tell you, I can't disclose what's in the IBA, but I can tell you the actual financial contribution is quite nominal. It's not even, it wouldn't even be a rounding error or material in an audit for us. What it did for us, though, that is exceptionally important, is it also guaranteed us seats on remediation and mediation or mitigation, the replanting, the remediation of the lands that are obviously quite disrupted. It had our knowledge keepers involved. So that was a concern for us. And I think there's a bigger question that we'll talk about later about what does that mean for IBAs? This is an agreement that Heather had talked about earlier that we're in support of. What happens now if we're not in support of something? Is the government able to walk in and say, no, it's now in your best interest, as they've done in this case? I think it's important to also recognize and I know Carol's following me, so I have to be a little bit careful. We actually have a statement of concern on the coal spur mine. And then so we had our, like I said, we have our IBA involved that was effectively dismissed. And I know to Carol's point, that's going to be an issue in a second. The second point we had was we actually have a large land claim called the title case, and it shows usage of Stonies, and it really runs from the 49th parallel up to about the Hinton area on the eastern slopes of the reserve. And really the JRP started to say, well, you know, the Stonies, we don't think necessarily use it as much as they should or won't necessarily be impacted. That's of concern. The third point, which I think is important, and I've touched on a little bit, is the environmental remediation of the site. As I mentioned, I would call this a blackfield site because it is so disturbed. Then we start to have concerns with coal, and I'm certainly not a geologist or a chemist, but you have the concept of selenium now potentially getting into waters once it's exposed to oxygen again. This is not a greenfield category 2 virgin side of a mountain that's going to be ripped up. This is one that was disturbed, and again, 50 years ago it was abandoned. We are unable to use this land and have been unable to use this land for the last 50 years. So I know that if a company now, in this case Riversdale Benga, is to produce out of that mine, they would have to remediate back to today's standards. So the concern that the Stoney Nakoda have is we would certainly like to use that land again, but if industry partner isn't going to remediate it, does that mean that the federal or provincial government is going to come in and remediate for us? Because it stands right now, it's an awfully large scar that we can't utilize our lands at all. So those are the three reasons why we appealed. What's very interesting to us and what's happened, and to clarify, we're seeking leave to appeal on the provincial JRP. That's the first step. And then presupposing we get that, we'll have an appeal. The federal government also came down just before the writ dropped. And to Sandy's comment on duty to consult, it was interesting, and then I'm sure Kara will speak about this in a moment. While all the nations in Treaty 7 had an IBA with Benga, the courts then ruled that Coal Spur, that the federal government couldn't arbitrarily walk in without recognizing consulting with nations that had IBAs, which is Ermineskin. They applied the same rationale to Stoney, and well, actually all the Treaty 7 nations. So we've now appealed on the federal side that the courts had just told the federal government that they had to consult with the nations that had IBAs prior to making a decision, and that was never done. For those in the audience that may know, we also would take a little bit of concern on how the federal government even did consultation. In Carol's case on Coal Spur, we are also a consultation nation, and we had less than 3 weeks to respond to consultation after the courts had forced them in Coal Spur, which anybody that's played in this field knows 3 weeks is way too short for us to have ever had a turnaround. But somehow the federal government didn't seem to think that court ruling applied to the Grassy Mountain case. So that's sort of where the Stonies are right now. I think it'll be interesting over the next month or two to see how this develops out. I'll try to leave it there, Heather, because I know I'm going to be squished on time at the other end.
No, that's fascinating. And thank you, Ryan. And I think for a lot of people who don't follow it closely, you might just think coal bad, environment good, and that's where it ends. And thank you for articulating why it's so much, it's much deeper than that. And so I'll turn it over to you, Carol. Then, Ryan's fed you a few lines that you can follow up on, but tell us about the Ermineskin case and the coal mine there.
Well, good afternoon. I was really surprised when we got a letter in July 2020 that the minister had reconsidered his position, just following requests by 2 First Nations and a group of environmental non-governmental agencies. We were not notified of this reconsideration. The minister subsequently chose to designate Phase 2 in the Vista Coal Mine project under the Designation Act. And in effect, for us, the designation order stopped development until an impact assessment could have been done. So in August 2020, we decided that we would seek a judicial review on the designation order on the basis that the decision was unreasonable and procedurally unfair, and the minister failed to fully fulfill the duty to consult ourselves. And so we went into court that way. Sorry, I'm just a little bit nervous. I don't know why. I'm usually not. When it was a non-designation decision, he sought consultation with 31 First Nations. When he redesignated it, he only went off the request of 2 other First Nations and non-governmental agencies. And I thought that was really unfair because we are now at a time and an age whereby Canada is not a good trustee. I don't believe they ever were for First Nations anyway throughout Canada, because historically we can look back and see those type of bad decisions being made. So if Canada has the right to do these without consulting First Nations who have impact benefit agreements that are an extension of our treaty and Aboriginal rights that are protected under Section 35 of the Canada's Constitution, then where's the consultation? Why did you leave us out? That area, yes, it's very disturbed lands. How am I supposed to keep protecting land? How am I supposed to keep protecting water? And how am I supposed to keep protecting those rights that are protected under Canada and those treaty obligations that should have been sitting there? We live in a world where I wasn't even allowed to, even though my hunting, fishing, trapping rights are under Canada's Constitution, I wasn't even allowed to create an economy from that. So at what point do I quit being on the periphery looking in? At what point do we as First Nations stand up and act sovereignly and start making decisions that protect our long-term interests. I work for the children that aren't born yet, and I'm trying to retain at least some legacy and a piece of land. And at what point do I quit being the steward so that I can sit and know that, well, not sit, but participate in being part of a framework that looks after water, keeps an eye on it, that looks after the soil, keeps an eye on it, looks after cumulative effects and keeps an eye on it. Canada is still so colonial. The way they treat us, the way they talk to us, the way they make decisions on our behalf. At what point are my economic rights supposed to be protected? I think this was an incredible win for Ermineskin Cree and also for other treaty nations within Canada and Indigenous groups. It's recognizing that, yes, we are sovereign. We've been here a very long time, and we've been complaining for a very long time. I think it's right when elders, parents, especially my parents, told me to go get educated and go learn that English language. Because this English language, one word has 7 terms and definitions to it, depending on how you use it. And that's how Canada continues to legislate and policy us away. I know I get quite passionate when I talk about this because it's my history. It's my stories, my connection to these areas. And if I'm not participating to help maintain and reclaiming and rebuilding and looking after the waters so that the children that aren't born have a legacy, then I don't think I've done my job as a human. I've been in consultation for 20 years. I was even a consultation manager for Alberta, so that was a good learning experience. But I've always thought Canada and Alberta and the provinces need to work better in doing proper consultation. And if an impact benefit agreement or a mutual agreement or a working agreement can support my future existence, then I think that's good. I can't talk about what was in those agreements, but I can tell you this. They were important for the rebuilding of some infrastructure for my people, learning about reclamation and that business and actually being a real participant in it. And to continue to do what I'm supposed to do, to guard and protect the water and the land and the animals that I need to speak for. My elder, Agnes Smallboy, who is no longer with us, she hasn't been on this earth for many years, but she always said, we need to stand up and talk for the 4-legged, for the ones who fly, for the plants we use for our medicines. And where does that come into? Water and soil and land. If Canada is so stuck in their ways where they think I can't think for myself, or I can't act for myself, or I can't go and get a future, well, then they're very wrong. I'm tired of being held down by colonial policies that continually legislate me and my rights away. Canada doesn't like to hear we live in apartheid, but we do, albeit silent. It's very silent because we're legislated. So many policies. So for me, this review was incredible. I was surprised because, you know, sometimes these things don't work out in court, right? But this one did. Blueberries did. Grassy coal mines did. All of these were really important decisions that affect the future of my people and all the Indigenous peoples in Canada. And maybe, who knows, maybe we've set a format for other Indigenous peoples throughout the world. Because free, prior, and informed consent, that's what all of this is about. It's about my Indigenous rights, my human rights, because I was a people's before I signed treaty. Treaty didn't make me. treaty is an agreement. It's an international agreement between two nations that allowed Canada to grow and prosper off my back and my people's backs. Natural resources are taken away from us. And now because the world finally wants to be clean, almost like I'm being punished. And how can that be when I'm finally standing up for what I should be able to do for my future? I'm not going anywhere. The Indigenous people aren't going anywhere. We're here. In fact, Canada and the provinces are in my backyard. So I have a right to protect what I think is there to be protected. My history is in those eastern slopes. My history is in all those category lands that have been categorized. And even, I dare say, grandfathered to industry, but certainly not to me. So I walk a fine line when I do this work. I walk a fine line in trying to maintain who I am still. I walk a fine line in trying to create economic opportunities so that my people can grow, so that I have families that are able to live at a standard that is above poverty, because that's still our reality. And I know all of this stuff, it's all holistic, and at some point, we all got to work together. We all need water, we all need clean air, we all need land to connect to, because as human beings, that's what we need. And for me, this decision was incredible, because for the first time in my life, I heard that my economic opportunities are connected to Section 35 rights protected under Canada's Constitution. But yet, a minister and some courts have decided that they don't need to consult with us. Yet consultation is a very important part of my development and my people's developments. Mitigation, accommodation, compensation. I'm a big fan of those, always have been, because I had a oil production at Pigeon Lake within my traditional territory, my ancestral, never mind traditional, it's my ancestral territory. Right in my backyard for 50 years, we had oil being taken out of the land. Did we prosper? Maybe by passive royalty receivership, but did we really prosper? Where's the jobs? Where's the small businesses that get to grow from industries that surround communities? It never happened. Resource developers got all that money. And yep, I got a small portion of that, right? Just a very small portion. So when there's industries in the eastern slopes that are going to affect how my future is going to live, I will be there. I will participate. But I will participate in reclamation, in making sure that the water studies are done, in making sure that the animals that I'm supposed to also be talking for are being looked after. When you talk about consultation, I know people only try and think about what we always hear, right? Fishing, trapping, hunting, and gathering. Well, I'm more than that. My people are more than that. So those impact benefit agreements that we pursue are for the socioeconomic growth of Ermineskin Cree Nation. They're for the education legacies within my nation so that our people can continue going to university or whatever trade they want to go to and to pursue a life. That's how important all this stuff is to me. It's about life. Even water, when you talk about water, Nipi, there's a story to that too. Niapimatsuin. Water is life, we all know that. So again, I walk a fine line when I start doing impact benefit agreements, but they're for socioeconomic growth. They're for keeping an eye on the land and making sure we have a true partnership with industry. Canada's ministers and courts need to start thinking a little bit more generously on how they define my life. I have a mind. My grandmother used to say, Nista maisino. And that in English means me too, I'm human. I'm a person. And up until about 1965, I don't believe we were treated like people. I still don't believe we were treated like people. Until I have that sovereign right and that recognition between governments and agencies and resource developers, then I've entered this right to be considered a human, like goodness. Every time we go to court, we're protecting our rights as peoples. We need to be participating in these arenas. Because for far too long, we were on the outside looking in. Indian Affairs, or ICS as they're known now, were the negotiators. Indian Oil and Gas were the negotiators. And where was my place? Where was my presence? When I was a young counselor for Ermineskin Cree Nation, we brought in industry and we interviewed them and we chose who we're going to work with. How hard is that? You know, am I a child? Am I uneducated? No. We have very, very astute and smart and well-spoken people. I'm proud to be from Ermineskin Cree because we've always acted sovereign. I grew up being sovereign. And I think those are really important things that industry in Canada, researchers need to hear, because that's really the reality. Yep, we can go into court. Every decision that falls in our favor makes us grow and become stronger. And I guess that's why I chose to be work in this field. I certainly can't run away from it because I've tried. I'm just going to end with this. My name's my Cree name is Askio Galpista. Galpista man in Cree means you're left in charge of or to look after. Askio is Kikawi no, Mother Earth. So when you translate my Cree name into English, I am a keeper of Mother Earth's laws. And I don't carry that title lightly because it carries a lot of weight. But again, who do I work for? The children that aren't born. So all these legislations, all these court decisions, they're not falling on make-believe people. These are us. These are our people. And they're our issues. So I'm really proud of what we've done. I think this gives teeth to First Nations across Canada to know that our economic rights are spin-offs of those rights that are protected, because yes, our people still hunt, trap, fish, and gather. We still do ceremony because that's who we are. The experiment of residential schools failed. We survived. Maybe a little war-torn, but we survived. And there's many of us who've gone to universities and learned the language and learned all this stuff that go through, or sometimes you're just thrown in cold and you learn real fast. But these are, this is about life. And these are about my interests, my ways of living, my ways of celebrating life, because Nehiawon, the way to live, it's all part and parcel of that. I'm not sectioned up into little pieces like the world likes to put us in. We're all part and parcel of everything. So I need to continue standing and working for my great-grandchildren, because the grandkids are here now, but for my great-grandchildren, and make sure that there's legacies left for them. They have land, they have clean water, they have clean soil, so the medicines we continue to pick and use are kept clean. And I guess that's why I do this. So I hope I've educated you a little bit. I try and speak from the heart, because I always think that's the best place to talk from. And I thank you for listening. Thank you.
Thank you so much, Carol, and for reminding us it's not about clauses and paragraphs. It's like you say, it's about your lives. So I really appreciate that. I'm going to turn it over to Dwight now, and I know that Sandy does have to leave early. So as soon as we finish with Dwight, I'm going to turn it over to Sandy to talk a little bit also about kind of how he sees all this unfolding before we go on to the other questions. But first, let's hear from you, Dwight.
Okay, well, good afternoon, and thank you for having me on the panel. It's good to be here with Sandy while he can be here. He has many, many years of experience working in this space, and it's great to hear his perspectives. And I think we agree on a lot of things about the judgment he was speaking about. It's also wonderful to be here with First Nations that are fighting against government paternalism and ongoing government paternalism. That has led to some successful decisions against that ongoing paternalism. And I'm going to talk about the two decisions, the Blueberry decision, briefly, because as I say, I agree with Sandy on a lot of points on it. And then the Ermineskin decision. On each of them, I have 5 points that I just want to highlight as key takeaways from the decisions. On the Blueberry decision, the first 3 of those line up exactly with things that Sandy said, but I'm going to repeat them anyway because I think they're really important. And so one is the decision that Treaty 8 in particular, although I think one could probably reach a similar conclusion about other treaties on an appropriate record and so forth, but the decision of the trial judge that the treaty protects not just a set of discrete activities on some stereotypical list of traditional activities, which are important, but protects a way of life. And I think that's something where the Blueberry Nation has stood up against government paternalism and the paternalism of others that would confine them to specific categories, and has had a judge recognize that they're in a treaty relationship that protects their way of life. The second takeaway I would mention from the Blueberry decision, and again, it's repeating, but the legal standard for an infringement of treaty rights isn't at the point when there's nothing meaningful left, but it's at a point before. The judge talks at certain points about the idea of a tipping point from cumulative impacts. There's a point well before the end of treaty rights where there's an infringement, even in the context of taking up clauses in Treaty 8 or presumably other numbered treaties. And that third point is, as Sandy said, that the decision surely has implications beyond Treaty 8 for the taking up clause in other numbered treaties. And I think governments across Western Canada and into Northwestern Ontario as well, but governments across the West really need to be thinking about the implications of this decision and thinking about situations where Indigenous ways of life have been limited by taking up of land for agriculture and other purposes. And I'm in a province where there's a lot of land that's been taken over for agriculture. How have Indigenous ways of life assured under treaties survived that? And what are the implications today? There are big questions for governments to be engaged with there, and governments and First Nations to be talking about. The fourth point I'd make just briefly on the Blueberry decision is that on the one hand, there's been a significant move by the province of British Columbia towards working with the nation after the decision towards trying to develop solutions. And the recent compensation payment and investment in rebuilding the land is significant. The other hand of that is my point 5, which is although it's a good win for the Blueberry Nation, there's an aspect where one almost wishes this had gone up the court chain and been reaffirmed at a higher level, because this case involved a massive investment by the nation. Although they managed to do it really quickly, it's with 160 trial days. That's a lot of money spent on lawyers and other experts that's gone into this case. To have that kind of record to inform appellate decisions would have been really helpful in some respects in terms of getting an appellate level statement on cumulative impacts. In cases like Chippewas of the Thames on the duty to consult, we have a few lines about cumulative impacts in the context of the duty to consult. And here's a case that has a lot to say on it. And I just hope it will continue to inform scholarship and other cases in a way that it's not lost to a trial level decision in terms of the impact on the law. And so I think we need to keep talking about the decision and significance and make sure that other courts do pay attention to it in other situations where this arises. In terms of the Ermineskin decision, again, I have 5 points, and I'll try to raise them quite quickly because I know that we're hitting Sandy's deadline in a moment here. But I'll just say, first of all, it's a very contemporary case involving very contemporary issues about a way of life that continues, yes, in traditional ways, but also in modern ways that reflect a community's ongoing life, a nation's ongoing life. There's too much paternalism that doesn't recognize those aspects of Indigenous rights claims all too often, not just by governments, frankly, by courts too, that have written too many legal standards that are about economic rights that are to subsistence levels of this or subsistence levels of that. And what if a nation actually wants to get above the subsistence level and build for the future? I mean, there are big issues there. Academic paternalism, frankly, as well. There are too many academics running Indigenous rights classes where the term IBA is never mentioned. I mean, it's an adaptation. I mean, people are learning. But there's been some slow progress on that at times. The second point I'll mention about the case is just its significance in terms of shaping the legal significance and status of IBAs, impact benefit agreements, Indigenous industry agreements more broadly. There are big issues there, big implications there potentially for other cases. The third point I'll mention is that we're seeing some interesting extensions in the context of the duty to consult, this being one of them, but there have been several others in recent years. And this is one where maybe the duty to consult is now helping to protect the kind of thing it helped to foster, which maybe wasn't what the Supreme Court of Canada foresaw in Haida when they thought they were talking about the honor of the Crown and the Crown in a relationship with communities. And actually, we're seeing communities take up an engagement and Indigenous nations take up an engagement with industry in building for the future. And now the duty to consult is catching up to protecting that, which is something that sort of was encouraged by the duty to consult, but the duty to consult in 2004 wasn't really constructed around. The fourth point, though, is there are challenges ahead, and the Government of Canada, on my understanding, is looking to appeal the Ermineskin decision and is putting challenges against it. And I guess around clarifying the status of IBAs or something, they are insisting on that appeal. Now, it has value if a higher court affirms this and so on, but it's putting a challenge against the nation that didn't need to be there when there was this win. The fifth point I'll just say briefly is that we need to be talking a lot more about economic reconciliation as part of the overall reconciliation discussion, because it's fine to have a lot of fancy phrases and so on, but in terms of Indigenous nations really reclaiming their historic strength and recovering from the legacies that have gone on, there needs to be an economic stake at the table, and we're here in the presence of nations that have been fighting for that, and it's just a wonderful day to be talking about these decisions, but they are ones that we need to talk about a lot more and that are going to have a lot of implications here. So I'll stop there and we can have some more discussion later on.
Amazing, Dwight. And we'll definitely get back to the economic rights discussion. But Sandy, I know you've stepped in at the last minute. I appreciate it. And you have another meeting at 3:30. So if you just want to finish off some of your broad thoughts that you wanted to make sure you shared before you left us.
Well, I'm not sure they'll be particularly broad, but first of all, thank you again for having me, and thank you for everybody who's listening. I think this is a great session, and I hope that people take it away and spend some time with the decisions. I post most of the new ones that come out, and people say, "Oh yeah, I read the first paragraph of it," but there's a lot to learn from these, and there's a lot to think about. Secondly, I'll say that for Dwight's 3 points that he agreed with me on, of his 10 total, I agree with him on the other 7. Absolutely, we're in a world where, and Carol touched on this. Is it paternalism? Is it ignorance? Is it politics? Whatever it is, we need to get past this. I mean, we're used to now, although governments still mess up on a regular basis. Consulting on the, if an Indigenous nation is going to experiencing negative effects from something, we think that maybe we should talk to them. Do we just go through the process, or are we really sitting back and listening and paying attention and trying to understand and trying to make the problem go away? But we're nowhere close on an Indigenous group thinks that something might be a good thing for them, and should we be talking to them? But I mean, that's self-determination. That's Ermineskin saying, we're making a different decision on this. That's Coastal GasLink, where you have 20 band councils who have signed on to something. And I worry that politics interferes with this. We get to make a designation decision against a proposed coal development because that looks good on our political record. And we won't talk to First Nations who might be in favor of something. So unfortunately for all of you people from industry who are listening to this, your world just got more complicated again. That's nothing new to you. Your world has got more complicated many times over the last few years. I know that people will adapt, but ultimately it's about doing the right thing. It's about listening. It's about trying to find a place where you can agree rather than, if you don't think that you'll like what you're going to say, not even talking to somebody. And as Dwight highlights, if the federal government appeals the Ermineskin case, why are they doing that? And for the provincial government in Blueberry to have fought so hard and said, no, we think that Blueberry is simply wrong on everything that it says here. And when you read the decision, they took that position effectively. And then a trial judge agrees with Blueberry on it, and the province goes, oh, well, okay, well, we won't appeal it. So take a step back, and what are people doing? Spending their dollars in court on this stuff when you can be spending your dollars and your time and your effort at the table and trying to work things out. So I'll leave you with that. And thank you very much again for having me.
Thank you so much, Sandy. Everyone else stay put. We got lots more to discuss, but Sandy will let you gracefully exit. And you left. So thank you to all of you. This has been tremendous so far. I've learned a lot. You've given us a lot to think about and very sophisticated kind of points. The first question I want to go, and feel free for all the participants to start putting in your questions in the Q&A. I see some of those and we're going to start to get to those. If I can try to group some of them together. What you said, Carol, is that for the first time in your life, you saw a judge recognize your economic rights under Section 35. And that's what I thought was the most powerful part of that decision too. So for all of you, do you think that these cases are going to move the dial in terms of how the courts and the governments weigh Indigenous economic rights? I think we've seen that they've weighed, again, kind of the environmental side much more heavily in the past. And that goes to, there's a question here from Joseph Quinnell, highlighting that the federal court criticized the minister for only consulting voices supporting the designation order, and then again, inexplicably freezing out Ermineskin. And that also gets to a point from an anonymous attendee, the last one, thinking of how does this reflect, how does this support for economic rights? Dwight, this is probably a question for you. Is this reflected in the new impact assessment agency in the new C69, I guess? Does it allow for that? Does it contradict it? Or is there some space for it there? So I don't know who wants to start. Maybe Ryan, we'll go to you. We haven't heard from you in a bit. Do you think this is going to change how the courts, how governments, how everyone views economic rights?
Well, I would say I'm hopeful that the answer is yes on the court side. I'm less bullish on the government at any level, understanding that based on what we're seeing or what we've seen in the very near past. I think it's important to recognize for many nations, I'll speak on behalf of Stoney, but I think most nations, and following my friend Carol's comments, I think are important. for many nations, we're understanding the treaty and these agreements well. As Sandy talked about hunting, fishing, gathering, those were the economies at the time. We also are cognizant that there's new economies at the time, and these are new opportunities for nations to be having some self-determination, some self-sufficiency, some even self-wealth. And it's really important to understand that there's really many nations, us included, that aren't interested in the status quo of being on government handouts and trying to survive that way. Now, the federal government's never going to let us starve, but we're never going to excel with the federal government. So we have to be able to have the opportunity to rise up and really learn and participate in the economy that exists in our areas. Again, I mean, it's a little bit different for the reason of why we are appealing the Grassy Mountain argument, but on a larger scale, I have a lot of concern with the government's not wanting, or apparently not wanting, to recognize these opportunities in, whether we call them IBAs or whatever else, because it's important to understand, not only do we not necessarily want government dollars, but it's also important to understand that the consultation that has to happen on this applies to just about any land use. It's not just oil and gas and coal and fossil fuels. I've got several renewable plays on the go right now. I mean, it could be a unicorn farm, it could be a housing development, it could be just about anything else. And if we're not even allowed to participate or have those rights sort of at least recognized or reviewed, that's of great concern. Now, the bigger concern I have is this, is with IBAs, is if IBAs, and we have to understand really what they are the duty to consult. And I had this explained to me in the very beginning of my career by a wonderful lady that was an ADM at the time in the province. And she said, listen, you have really three groups that are involved in these programs. You have the proponent is a big group, and you have the First Nations or the Indigenous groups that are big groups. And we're all funneled up through a little tiny thing that's the government here, that are going to make determinations without really understanding the industry side or not really understand the First Nation side. So that's really where the First Nation and industry, the proponent, have to come together to really understand what each other are talking about, what our needs are, what our no-go zones are. And it's concerning to me when I would have a government saying that we know better, we're there to look out for you and your rights. That hasn't worked very well over the last 150, 170 years, that we're from the government, we're here to take care of you and do well for you. I think history is certainly awakening to the fact that perhaps that's not always the best option. And to Carol's point earlier, many people from our nations, whether they're in the nations, whether they're consultants, whether they're what have you, are educated and are experienced outside of just the nation. And that is part of self-determination from a nation, is we do know better than somebody sitting in the bowels of 10 Wellington Street in Hull, making determinations for the nations that have never been to these areas that they're talking about. So thanks, Heather.
Thanks, Ryan. Yeah, many of us have suffered through the bowels of Wellington Street. And yet, yeah, you make, and there's a few questions talking about that, about some of the questions of where the company is acting in good faith. But just to Sandy's point before he left, that this will make life more complicated for industry, and that's obviously true. But also in all three cases, this wasn't a case of nations being against development or being against industry. In all cases, I think they were trying to work more productively with industry. So I think Dwight touched on it, maybe he'll touch on it more of, what is the status of IBAs and how does that play into all this? Because like you said, that's a very high standard of consultation for a lot of these things. Carol, before we get to Dwight, maybe I'll just get back to you. Do you think this will hold? Do you think recognizing your economic rights is going to find itself into higher courts and going to find itself accepted? Or do you have concerns that it was just, kind of one appeal judgment and it might get swept under the rug again?
I have to be careful how I answer this one. I would like to believe that this decision will be the pioneering road whereby we can build economically. I've been on the outside looking in for far too long. I've been kept from growing. I've been kept from developing myself so that we can employ people. I want economic growth to continue because I'm sick and tired of living on welfare. I have 4,500 people on my reserve. We've grown from 367 in 1968. It's a lot of people. I can only employ 250 people, and that's not all my people because I have people from the outside who have expertise coming to work with us too. But wouldn't it be a wonderful world for a First Nation to finally be able to say that I have 2% of my population living on SA because that's what they choose. And the other 98% are able to live well, live and eat well, have homes that can be heated. Because that's what all this stuff trickles down to. It's about life, you guys. It's about life, but Canada still forgets. I know industry feels like they're left holding the money tag, but industry also needs to step up and be part of this. Can we? I hope it does. There, that's just the plain answer. I hope it does. Thank you.
I hope it does, Carol, too. So let's go to Dwight. Maybe Dwight, how does this become more of a standard? What would that process look like? And if you can comment, I've lots of questions coming in for you on the impact assessment, the new Impact Assessment Act, if that reflects this at all, or it can't. And then someone else also asked about the oil tanker ban, which to me is related. Does the Ermineskin case allow for someone to challenge the oil tanker ban or the cancellation of Northern Gateway? How retroactive can this be?
Okay, so there are lots of questions that arise, obviously, in terms of how broadly impactful this is. And I would just say, first of all, in terms of industry taking up its part, I don't think industry needs to be frightened by these kinds of decisions. I think these are decisions that are recognizing the economic relationships between Indigenous nations and industry that's ready to engage in real dialogue and meaningful dialogue with Indigenous nations about how to build wealth together. There's actually a protection there against government interference that arises from a decision like the Ermineskin decision. That's something to be thinking about, because too often governments are making decisions that just don't have any awareness of implications for resource development in Western Canada. These kinds of decisions offer a protection for the kinds of resource developments to which Indigenous nations are open. While an IBA can also carve out, as was described earlier, the no-go zones, can develop a process for ongoing relationships between the Indigenous nation and industry. The question about the impact assessment agency's new guidelines and whether they take account of these decisions, no, they don't, because they were done a little while ago. And I guess they're in the very bureaucratic language of government, and they're crafted very carefully to not develop any kind of really creative new approach. And I mean, that's not exactly a criticism of them. In a way it is, but it's sort of, there's nothing that exciting that's going to come out necessarily of that kind of process in terms of this new kind of area that's under discussion finally in terms of economic rights of Indigenous nations. This discussion needs to move further along before it starts filtering into those kinds of guidelines. But there are other questions out there where these issues are at stake, similar issues, and something like the oil tanker ban or a challenge to the Northern Gateway pipeline cancellation by Indigenous nations that we're going to be equity partners in it. I mean, this kind of jurisprudence would contribute to those causes. It doesn't exactly operate retroactively, and it may be too late for some of those cases. there are very detailed questions that go into that. Something like the oil tanker ban, there are complications of to what extent one's talking about government policy / legislation, and does that raise some different issues as compared to an administrative decision that has a negative impact on an Indigenous nation that has an IBA. But the idea that Indigenous economic interests would receive legal protection, that broad idea is one that's been meaningfully advanced in a case like the Ermineskin decision, and that has implications for all kinds of other decisions if it's upheld in other discussions. And I think it needs to be, and everyone needs to be talking about these issues, because these issues are about the future of Indigenous nations, that they would have economic opportunities and not continue to face the same kinds of restrictions they faced too often from government policies that have held them back in the past. And so there are indirect implications for some of these other contexts that are being asked about in the questions, but each of them raises some additional issues and would require sort of a webinar of its own to get fully into.
I hear you inviting or agreeing to come to some more talks on this. So fantastic. Now, my next question is going to be for Ryan and for Carol. I'm going to combine two questions from the Q&A here. Richard Dunn asked that his understanding, so Ryan, this is really for you, but Grassy Mountain panel had significant concerns with the efficacy of the technology the proponent was proposing to mitigate potential environmental effects. That was the basis of their judgment, was that they didn't believe the company could do what the company said it was going to do. And another participant asked you both, do you have concerns regarding the promised economic benefits versus realized benefits when it comes to, companies like Benga and Coalspur Vista? Do you trust, or how do your nations trust that they'll do what they say in the IBA? Ryan, let's start. There we go.
Sure. So I guess to answer Richard's question on it, that's really the technology side of it and the geologist or chemist side of it on selenium. Yeah, that's an issue that was raised on it. That's not what we've appealed on. Our concern was more around the language. And it's interesting when I said the remediation, and it might actually roll into a little bit of the next question. Some of the language used, one of the paragraphs is, overall, we find the project will result in the loss of lands used for traditional activities, and this would affect Indigenous groups and their members who use the project area. The mitigations proposed are not sufficient to fully mitigate these efforts. Interestingly, one of the biggest issues we're having is we'd like it returned back, not to what it is now. We want it returned back to what it was at the beginning. So again, our appeal, I would defer to Benga Riversdale on that part for Richard's question. I do think that we probably want to watch on the ECDEV argument. Ours really isn't an ECDEV on the dollar driver either on this. It's really the opportunity for our people to have better opportunities that are transferable skills, right? I mean, we're dealing with nations that still have incredibly high unemployment rates. I think it's worth us recognizing that Indigenous communities tend to be exceptionally overrepresented in the resource extraction areas. And that really comes from, we don't build these things in cities. We don't build mines, we don't have forestry, we don't have oil and gas in cities, we have them. So for us not to have these opportunities to either work or have dollars from an agreement, which again are minimal in our particular case, it's the work opportunities, the mitigation opportunities, the environmental opportunities that are interesting for us. And when we don't have these projects, we are, and there's studies, Kelly Lindsay's group, and I'm gonna screw up his quote, so this falls on me, not on him. Indigenous group people are 2.5 to 3 times as likely to be in the extraction sector than Canadians, average everyday Canadians are across the board. So when these projects are impacted like that, that has huge overlying concerns for us. Now, as far as the cleanup goes, because I did see one of the other questions, I'm going to segue a little bit, Heather, if you're okay with that. Do we trust the industry groups to do it? There's all sorts of ways to do it. I can tell you, we just opened a gravel pit in Stoney. We have to post a reclamation bond in advance. There's no reason. There's all sorts of ways we can do that. I can tell you, I don't have a lot of faith in the government doing it, considering it sat there for the last 50 years with nothing being done on it either. So, you know, is industry the full answer? No. The other option I would say to you, I'm not really that interested in the government being the overseers and doing this. If I can have a private industry pay for this rather than us pay for it in taxes, then I'd be interested in looking at that too. I think we all pay enough taxes and know they're going nowhere but up. That's the concern that we would have. I would make them post, we do it in construction, we do it in big projects. There's no reason they can't post a performance bond, irrevocable line of credit, etc. But I don't have great belief that's going to be the government that's going to do it either, nor do I particularly want them to do it based on our taxes. I mean, we have to remember our IBA agreements, it's having the nations lead these reclamations and these mitigations. So thanks, Heather.
Awesome. Carol, how about yourself? Do you have faith that your IBA will be upheld and you'll get the economic benefits that they committed to?
Yes, I do. Why? Because I've already had a benefit agreement with them in the past, and they upheld those. If I have to be so careful how I word some things. I have faith they will be followed through because they're a little bit of everything for us too. It's about work. It's about reclaiming the land. It's about putting water, trying to be a good steward so that I have clean water for the future. I don't trust Canada to hold it for me, that's for sure, because again, my experience here in Musquecheese, was Canada good at that? Nope. You know, we've had many arguments with Canada and we've won them. I'm always really happy when we win our discussion. So obviously we're explaining things in a proper way that protects me and my future. You know, Canada's not been a good trustee. Because that's what they had told us for many years, right? They're my trustee. They hold things in trust for me. I think it's time I hold things in trust for my future and my people. That's our responsibility as a nation. Well, Canada, I don't know. It's, you know, I have to be really careful what I say about this. And because God knows what Canada is going to do anyway. They've already making their decisions and moving forward. But you know, if things move forward and things work out really well, yes, I believe these agreements come forward. I have a lot of past experience with other companies where those impact benefit agreements did grow. And what they said we were going to do happened. Might have to wait a little while, but that's okay. Because I've also lost IBA impact agreements because pipelines have been shut down. And that's okay too. Would have been nice to have some of those dollars so that I keep growing our people and our infrastructures and looking after stuff. Canada doesn't give me enough to grow. In fact, I've always said this from the time when I was a young woman, Ermineskin Cree Nation has subsidized Canada. We've never gotten what we should in order for our people to move forward. Those little pieces of crumbs, sometimes I feel like a pigeon, and I don't like being a pigeon because everybody fights over those crumbs. How come I can't make my own living? How come I can't create my own destiny? How come I have to stay stuck? Because I always have to prove what's out there, right? That this was our ancestral lands, that we were actually here before treaty. When do I get to decide my future? And when do I get to really say that I look after my future? Because I better leave something when I leave this earth to those little people that aren't born yet. That's all I don't know, that's just my own personal opinion. I get really passionate about this stuff, but that's how I was taught. That's what I was told. Carol, you work for the future. The children that aren't born here, that aren't here today, that's who you work for. And how do I create a world for them that's better than the one that we have here right now? Because it's pretty dismal. I know there's a myth that Musqueam is really rich. We probably are. We're probably well off, way better than a lot of other First Nations. But those were, I think, really fought for, especially in the 90s, the 80s and 90s, where Canada was not a good, I better say a nice word, was not a good trustee for me. Canada took my dollars and built houses, built roads, hospitals, and schools, and never paid us back. They took our money, and did they give me interest on that? Nope. We never received a cent of interest. So how come I can't be my own person? How come I can't develop that path so that I have economic growth and something for the future? So that I have proper housing, so I have proper water. You know, a lot of us live still under water advisories. I know that's not the discussion of today, but that's what this is all about. It's about what's at end of day in my backyard. And my backyard consists of Alberta, Saskatchewan, Manitoba, crossing over into the United States, all the way back to Washington, on the other side of Vancouver, BC. That's my territory. You know, not just what's now known as Alberta.
Mhm.
My territory is huge. My ancestral lands are huge. I used to have economic benefits because I truly believe this. We were the traders, not traitors. There's a difference. We were the traders, TRADERS. We had economic growth. We knew we had economic maps that extend from what's now known as Quebec all the way down to the Mississippi. Those are trade routes. I had an economy. How come I can't have an economy again? Signing treaty didn't take away my economy, but the foreigners thought that took my economy. So I guess it's a good question what you asked me. Do you think it's real? Yeah, I do, because I like to believe what we put together. There's light at the end of this tunnel too, and it'll be economic growth and economic opportunities. Thank you.
Thank you, Carol. I'm going to throw one more question to Dwight before I have to start closing things up. There were a few questions about Treaty 8 and Blueberry River at the beginning. The way I have heard a lot of them, Dwight, is people are wondering, how does this impact other Treaty 8 First Nations? How does this impact other treaty territories? And does it have an impact on non-treaty nations as well? How do you see this trickling through?
Well, that's a big question. I guess I'd say I agree with Sandy's comment that a lot of what the trial judge does in this case is engaged with the process around Treaty 8 generally, and the historical evidence that's referenced there isn't about the specific adhesion of the Blueberry River First Nation, but is about Treaty 8 generally. And to that extent, it is an important ruling on Treaty 8 more generally. Now, as I said before, in one way, it's really good that BC has gone along with this decision and is working with the nation and getting things done rather than continuing to fight it in court. There would be something that would be nice about a higher appellate affirmation of the decision that would be helpful for other Treaty 8 situations. But this decision itself speaks to Treaty 8 and I think has broader implications for Treaty 8. In terms of the questions about the applications to other numbered treaties in particular, I guess there was a question about the wording around the usual vocations clause. And I was just comparing quickly the treaty text to Treaty 6, and I haven't compared every treaty, but the wording is actually pretty similar on that. And so I don't think that there's a differentiation based on that wording. I think the argument that other treaties were also to protect ways of life rather than lists of specific activities has a lot of potential to be carried over to other contexts, but it does depend on the record that would be put in a particular other treaty case. And that's unfortunately the situation we're in, unless governments will work a little more reasonably than they have at times. If there needs to be litigation in other contexts, it would need to involve some of the same kind of record being put forth. In terms of non-treaty contexts, I guess I'd just say, in one way, jurisprudence about the treaty context doesn't translate over easily. In other ways, it does, because at some point, something like the idea that there's a protection for Indigenous ways of life, rather than just discrete activities, needs to be the way that we start thinking about things more fully. And that's something that's present in the UN Declaration on the Rights of Indigenous Peoples in meaningful ways. We've got new legislation on that. We've got a whole set of questions on what does that mean and what's the process under that, and future discussions to be had. But something like those core principles that Indigenous ways of life and contemporary, current modern ways of life, continuing from past ways of life and building upon tradition, but carrying forward into the future, that's what things are about, rather than a list of this activity or that activity in these limited ways. Well, we need to get to that level, and I would hope that this kind of discussion informs discussions and case law in non-treaty contexts as well. But there's a long road ahead. There are a lot of discussions to be had. Unfortunately, a lot of cases to be fought in future. But I guess these cases have huge promise. The Blueberry decision on treaties has a lot to say. The Ermineskin decision on IBAs and economic dimensions, really important decisions. And we're just in a very fortunate position to be here today talking about these wins rather than what could have been if the decisions had come out otherwise.
Great point, Dwight. Before we wrap up, Ryan and Carol, you guys have about 30 seconds. If you had any final thoughts that you wanted to offer the audience before we close up. Ryan, did you have anything you wanted to share before we go?
No, I'd just like to thank everybody for hearing a different, hopefully a different perspective from a First Nation and how we'd like to participate, why we'd like to participate, and why we've appealed a coal case. And again, it doesn't fall to coal at all. It really falls to self-determination and our wanting to participate and not sort of be on the government role. You know, as I've had many discussions with my government, I have lots of friends in government. Governments aren't in the business to be in government. And when we want to pick our dance partners, we're much more interested in looking to industry to help us. As Carol has said, and as I've said, we have a long history of why we wouldn't necessarily trust that the government's going to be the best keeper for us. And I'd also have people probably draw attention to the fact that, and I came from a industry partner before I came to Stoney directly, the Indigenous spend by industry is multiple times exponentially higher than what the government of Canada spends. So proof is in the pudding that when we're looking for economic partnerships, it's with industry, not with the government. Thanks.
Thank you, Ryan. Carol, you have about 30 seconds if you can.
Okay.
That. Thanks.
Thank you. I agree with what Ryan says throughout this whole session we've had. It was good to hear that perspective. I'm really thankful I had this opportunity. I know I was really nervous, but I think industry, Canadians, Albertans, and people globally need to start understanding us. We are more than feathers and beads. We are a people who want to leave a legacy for a future. And I think it's time we started getting recognized that that treaty relationship created Canada, helped create Canada. but I never became a full participant. And I'd really like to be a participant in Canada's situation because it affects my life. I also want to acknowledge that I'm really happy that I come from people who are strong and really believe in themselves and didn't allow themselves to die. We've been pretty vocal all the time. I was raised to be vocal, and I appreciate the work I do for my people because it's really long-term stuff. It's not just about money. It's about leaving legacies so that our kids can live. Thank you.
Thank you, Carol. Thank you to all of our participants for your attention today. It was a fantastic discussion. I agree with everyone. This is the beginning of a discussion that we'll be having, I think, for years to come. Thank you to the School of Public Policy and to the Extractive Resource Governance Program for hosting this. Have a great afternoon, everyone. Thank you.